Professor Yannick Radi is a professor of public international law at the University of Louvain, but I should add that he was here before. So in Belgium, he is a member of the IUSCT panel of arbitrators. Yannick will deliver a special course at the Hague Academy of International Law in 2026, January, on property and international law. He has written extensively about investment law matters, notably rules and practices of international investment law and arbitration, a textbook published by Cambridge University Press in 2021. So welcome back home, Yannick. Yeah. And then Dr. Jason Rudall is assistant professor of public international law. He's the one who is now my office mate, by the way.
It's a great panel.
You see. So Jason is assistant professor of public international law at Leiden University. His research interests lie in public international law, international environmental law, international investment law, and dispute settlement. He has published monographs on compensation for environmental damage under international law, the responsibility for environmental damage, and of course his monograph on altruism in international law. So he has several articles and book chapters that address inter alia, state responsibility, reparations, valuation techniques, and equitable considerations. And then Amelia and I, Amelia Keene, we were at the ICJ, more or less at the same period. So she is a legal advisor to the president at the Iran-US Claim Tribunal. She was previously a senior associate at Three Crowns LLP in Paris, where she acted on behalf of both states and investors. She has appeared as a counsel before the ICJ and in numerous investment and commercial arbitrations. She was also the associate legal officer for the late Judge James Crawford at the International Court of Justice, and her most recent publication focuses on the application of the articles on state responsibility in investment arbitration cases. So thank you very much for joining us this afternoon for this panel. As indicated before, I will first give the floor to Borzu in order to provide us with a framing presentation of the question. Everyone talks about the Chorso factory, and but we understand that the law on compensation goes beyond that, and therefore we are very grateful that you're going to provide us with that.
Thank you very much for the introduction. I'm very honored to be here and get admitted to this very close circle, I have to say. I didn't know, now I know. I'm delighted and honored to be also here. I thank our organizers. This is wonderful, and the history of me being involved with this subject matter goes for a decade, whose Antonio explained. I'm not going to repeat it. Well, I don't have a long set of remarks, so let me just jump directly on the topic assigned to me, which is the impact of PCIJ and ICJ judgments on IUSCT jurisprudence in connection with the assessment of damages. Well, as much as I think my colleagues, they want me to go and talk a range of cases, I'll have to disappoint you. I'm just going to talk about Chorso, and maybe we talk about other things as well. And any discussion of this topic is really bound to focus on Chorso factory case. And I didn't really do an empirical research to figure out, okay, how many times Chorso was cited and in which cases. I just looked into my own practice. I mean, I've been practicing for about 20 years. I've been involved with a bit more than 30 cases. And in every ISDS case that I have been involved, the case has been there. Both parties, and each one of them are citing it, and it has made it to the awards. So I thought, you know what, I can be lazy here, and this is it. This is the case, the landmark case. And then, so I think that's what I'm gonna spend my time on it. And I think it's probably the most cases cited case among all the PCIJ and ICJ cases in the ISDS. Feel free to challenge me if you want to go on. Let me start then by briefly reciting the key facts of the case. As you all know, the dispute arose more than 100 years ago. It involved the Polish government's taking of the Chorzów factory and some other property belonging to two German companies located in Upper Silesia. Under the Geneva Convention of 1922, the Polish government had undertaken not to expropriate the property of German nationals. So upon this taking, Germany espoused the claims of the two companies and brought a claim against Poland at the PCIJ. The PCIJ, in a decision on liability, found Poland in breach of the obligation not to expropriate and some other provisions in the Geneva Convention. Then in a subsequent decision on indemnity, which was rendered in 1928, the PCIJ, chaired by Judge Anzalotti, touched upon a number of principles that have shaped the modern system of reparation, I submit. Today, I want to touch upon some of these concepts in this presentation. First, the principle of reparation itself, and the but-for scenario, or the hypothetical scenario, as you want to call it, or a counterfactual scenario, whatever you want to call it, to quantify damages. That's probably the most important. The court explained it in following terms. Reparation must, as far as possible, wipe out all the consequences of the illegal act and reestablish the situation which would, in all probability, have existed if that act had not been committed. Restitution in kind, or if this is not possible, payment of a sum corresponding to the value which a restitution in kind would bear, the award, if need be, of damages for loss sustained, which would not be covered by restitution in kind or payment in place of it. So that was the general principle. I cut it short here, but that captures it. This statement really encompasses the basic idea that an illegal act creates a secondary obligation to repair the harm caused, which is really the duty of reparation. And the ILC articles also refer to it for this proposition. Applying this abstract principle, however, is easier said than done. The PCIJ's instructions later in the judgment to the experts that were hired, they were damages experts, technical expert hired to quantify damages, sheds more light on how this abstract principle should be applied. The court asked the experts to address three questions. Well, two questions, but in effect, there is a third one buried in it. So I say three questions. One, what was the value of the property at the time of the taking? Two, how much profits the property would have made between that time and time of the judgment? Had it remained in the hands of the German owners? So there is already some hypothetical analysis that you're just assuming that this property had not been passed from them to the Polish government. And three, what was the value at the time of the judgment had the property remained in the hands of the German owners? So the idea was to assume the illegal act and its consequences did not happen, and then capture profits that the companies would have hypothetically earned between the time of the taking and the time of the award, as well as the but-for value of the property at the time of the award. The sum of the two would repair the harm caused. And that's important because the value at the time of the award, you're buying the company looking into the cash flows that it would generate into the future. So you're capturing the past and you're capturing the future, discounted back to the date of the judgment, not to have a double recovery. So it is notable that both in the reparation principle that I read to you above and in the questions to the experts, the court uses the word probable, quote unquote, to refer to the level of certainty required for this assessment. Ultimately, the case was settled, and the court did not have the chance to further elaborate on it. So that's one of the ironies of life. For 100 years, we have been citing it, etc., but it has not been. But there was enough probably guidance there for everyone to kind of work with it, and that's what has happened with it. Modern ISTS cases have applied in a number of cases, the battle focusing on what information and assumptions may or may not be included in the but-for scenario. This is where a range of legal issues on the domestic law, as well as a number of factual issues, will all have to be considered to build up a proper hypothetical scenario. For example, for how long the expropriated business would have operated, what sorts of laws would have applied to that operation, where, for example, taxes payable, any royalties were due. External economic and non-economic events would be relevant too. For example, if the company was involved in selling commodities, the prices of the commodities, such as oil on international markets, would be an important driver of value that needs to be considered in the but-for scenario. So that's for the but-for scenario and reparation. Second point that comes out in the judgment is the difference between a lawful taking and illegal acts in terms of the amount of compensation due. And I say illegal acts in a broad sense here to include both an illegal seizure, which was at issue in the Chorzo factory case, as well as modern treaty breaches, like, for example, unfair and equitable treatment, etc. Under the Chorzo's principle, the valuation date can be detached from the date of illegality and moved to a later date. This phenomenon, if I may call it one, is something that may not seem intuitive, but that's how Chorzo has been applied. Here are the instructions of the PCIJ to the cases. The first modern ISTS case to embrace it was ADC. A bunch of other cases after that, they have kind of applied it in that fashion. The idea was to really give the claimant the benefit of the appreciation in value in the post-taking period. I should note that in the PCIJ's decision, the taking would not become illegal when only the compensation is missing. That is reflected in the following passage of the case, which is kind of not as much actually been paid attention to. And this is a quote: "This limitation, valuing interest at the time of disposition, would only be admissible if the Polish government had had the right to expropriate and if its wrongful act consisted merely in not having paid to the two companies the just price of what was expropriated." So one may contrast this with the whole formula's requirement, which was announced 10 years later, 1938, and then required that compensation be prompt, quote unquote. And a lot of modern treaties also incorporate that whole formula, which is kind of, I think I hope we get some comments on that from my colleagues. The third point that I want to kind of raise is probably a conclusion that comes out of the main reparation code that I read to you, is just the use of hindsight information. That's an important implication of application of Chorzo, which is you can use the information obtained with the benefit of hindsight to value the lost property. That's the so-called ex post approach to valuation, to borrow a term used by valuation experts. The idea is to use all the information available after the illegal act, except, of course, those that result from the illegal act itself. Revenue enhancing factors may, for example, include increase in oil prices for an oil project. Revenue reducing factors may include a host of economic circumstances that may depress the value, like an economic crisis, a war, or perhaps a pandemic. Using hindsight information together with a low discount rate when discounted cash flow method or the DCF is used can dramatically increase value this dynamic was at full display in several cases, like the Venezuela holding case. Respondent in that case was able to avoid a multi-billion-dollar damages claim. There are, however, many other examples of multi-billion-dollar damages awards that has been kind of put together in this way. And we have the Ancestral Working Group 3 trying to kind of contain that. They have a kind of set of principles on guidelines for assessment of damages. They're working on it. It's in the works. Fourth, embedded in the Chorzo case is the principle of causation, I submit. That follows from the statement that reparation must wipe out all the consequences of the illegal act. So that's the objective of the reparation. Chorzo is less cited for this proposition, but of course, I think the principle plays an important role in constructing a proper but-for scenario. The nature of the causal link in this context may be something that the panel, I hope we get some discussion on it. What is the test there? Is it foreseeability? Is it proximate causation? Or is it something, as Professor Stern says in Kiborax, should you kind of ignore the external events? And so I leave it at that. And finally, I'm going to a little bit move away from my task with the indulgence of our moderator. I couldn't resist saying this, but I just want to say something on the climate change. I'm sure Jason is going to talk about it in more depth, but you're well aware that in recent years, many companies have started adjusting their policies to make sure that they continue operating profitably in our warming world, if I may say so. Whether or not a government supports climate-related actions, it is undeniable that these events affect business. Can, for example, a company operate in Southern California ignoring the risk of wildfires? The but-for scenario under Chorzo need to take such contingencies into account. The problem is that unlike many other factors, there's not enough information on how to measure and quantify such risks. Efforts are, however, are underway to incorporate these elements into valuation. Disclosure rules, for example, about a public company's environmental footprint, for example, have been developing in recent years. They would signal to the markets as to how a business may be affected, presumably leading to some downward adjustment in value. Earlier this year, International Valuation Standard Council, or IVSC, released its IVS 2025, which is an important reference for valuation experts. This new set of valuation standards, for the first time, contain an appendix which calls to valuation experts to take into account ESG factors, including climate change. And with that, I conclude my remarks. And thank you very much for your attention.
Thank you very much. And panelists, any comments? So now let me give the floor. Now each one of the panelists will try to build upon the various aspects of what Borzu just said. And I will start first with Yannick, who is going to discuss again certain aspects of Chorzo and the principle of full compensation. Yannick, you have the floor.
Thank you very much, Mamadou. That's a pleasure to be back in the same room to discuss Jason, this part of it. Has replaced me, so it's nice to meet you, Jason. So I would like to start with a caveat and even an apology to all Polish native speakers, either in the room or online. I would like to apologize indeed, because the case I will obviously focus on has a Polish term. So I was saying that it should be pronounced Borzu. I don't know if this is correct or not. But as you can hear in the terrible accents, I would stick to my French / English version of the term just for the sake of, in the interest of time. Okay. Because we have 5 minutes, so I will do my best to fit within those 5 minutes. And during this time, I would like to speak about the relevance, actually, of Shorthaw and of the full reparation principle in the investor-state arbitration context. So that relevance has almost always been taken for granted by all tribunals without them providing any explanation, as has been more generally the relevance of the RCWA in investor-state arbitration, even though we know that there is a distinction to be made between part 1 and part 2 and 3 of the articles. And yet, one could have expected from tribunals to provide some explanation when applying Shorthaw and the full reparation principle in investor-state arbitration. Why? Because on the face of the judgment, if you read it cautiously, this is not clear whether it applies as such only in the interstate context, or whether it has a broader reach encompassing in particular private person state context, and in particular the investor state context. So to realize this, let's get back to the basics, the text, as we do with our students. Please. Thank you very much. So let's start with page 28. So I will not enter into the details. If you go through it, you really understand that Anzilotti was the president. It's a very dualist approach to international law. But here what I'm interested in is the sentence which is in bold. So the rules of law governing the reparation in the case are the rules of international law in force between the two states concerned, and not the law governing relations between the state which has committed a wrongful act and the individual who has suffered damage. So, based on this, the full reparation principle seems to apply as such only in the interstate context, then the private person state context being excluded from its scope of application. But that's not that easy, and now let's focus on another paragraph that you have just mentioned, the one which is almost canonical in the discipline because, as you say, I do believe it has been quoted in all awards touching upon quantum matters. So you know it. Can you move on, please?
Yeah, sorry.
Thank you very much. So actually, I'm interested in the first few words and in the last few words. So first few words say the essential principle contained in the actual notion of an illegal act. The last few words, so such are the principles which should serve to determine the amount of compensation due for an act contrary to international law. So what does it mean? It seems to mean that the illegality of the state act, that is the illegality of the state act, which grants the full reparation principle, then the nature of, so to speak, the beneficiary of the obligation to repair, be it a state, an international organization, or a private person, being irrelevant. So then, in the same way as the rules on state responsibility as codified in part 1 of the RCWA apply as such beyond the interstate context without any doubt, the full reparation principle, construed as deriving from the International Wrongful Act, could be said to apply in any context. So, also, limited or not limited to the interstate context? That is actually the question. And this is a fundamental question which has been answered either way. as both interpretation of the judgment has actually been argued. So, as it appears, depending on one's own reading of the judgment, the relevance of causal and of the full reparation principle in investor-state arbitration can be argued either in terms of direct application or in terms of analogy. But in both cases, explanation need to be provided. So first, the idea that causal is applicable directly requires to be supported by authorities, so state practice, subsidiarity, case law, authorities which evidence that the full reparation principle is applicable equally, whatever the context. So in this respect, and looking at this from the standpoint of the ICJ, the Diallo case is interesting. It is interesting as the court, in that case, referred, that's the previous one. Yes, thank you very much. So as the court in that case referred to a private person state context to discuss compensation matters, it referred, I said this morning, to the case law of human rights courts. As you can see then on the slide, so it's a declaration by Judge Greenwood, who justified this approach, so relying on case law in a human rights context to apply it in an interstate context. That, well, international law is a unified system. So then there is, it can be applied equally, whatever the context under this approach. But then, if one considers that causal is applicable by analogy only, this is obviously the analogy which is to be justified. And also very importantly, it is worth noting that an application of causal by analogy opens the door to possible adjustment of the full reparation principle, taking into account specific factors to determine compensation in investor-state arbitration. And in this respect, it's very interesting to look at recent treaty practice to shed light on potential specific factors. So Mamadou, this is something I discuss later, or do I still have a bit of time?
You still have 2 minutes, is that okay?
It would fit. No problem.
Okay.
Thank you, Mamadou. So let's start with Iran Slovakia BIT 2017, which provides that any award of damages shall be determined in accordance with the generally recognized international principles of valuation and taking into account, inter alia, an equitable balance between the public interest and interest of those affected, the purpose of the measure, the current and past use of the properties. So factors which can lead to adjust the full reparation. Likewise, if we can then move on to the 2024 India United Arab Emirates BIT, which is actually based on the Indian BIT model. So here, as mitigating factors, Maya, if you don't mind, please. The next slide. Thank you very much. So as mitigating factors, that treaty again refers to the need to balance public interest and the interest of the investors. It also refers to unremitted harm or damage that the investor may have caused, again, as factors to be taken into account to determine compensation. So just to conclude, one can only but welcome that states in the lex specialis in the IAS have started to take compensation seriously, as this contributes to bring clarity, which is very much needed as regards compensation, as it is as regards many aspects in our field and discipline. Thank you very much for your attention.
Yes. And Yannick's views? Yeah.
Yeah, maybe one thing springs to mind since you mentioned Diallo and Judge Greenwood. He has a really thought-provoking line in his declaration. Actually, he says, "Equity is not alchemy." if I'm not mistaken. And he speaks about, you know, equity, the possibilities of equity, but warns that equity shouldn't be a substitute for claimants' duty to meet their evidentiary threshold. And I think sometimes, in discussions of equitable considerations and the role of equity as a sort of way of softening the impact that the strict application of legal rules can result in, sometimes we forget actually that there is perhaps a methodologically sound way of applying equity, and maybe some of the things you spoke about, Borzu, in terms of sort of the role of science, the role of experts perhaps that they could play in determining what role or amount of equitable considerations ought to be taken into account.
Yannick, is equity alchemy?
But I mean, it's interesting if you look at the commentaries of the IUSCT. The term is used as in relation to compensation. So lawyers are turning around on the black hole. But there is obviously a need. Anytime, I mean, as arbitrators, we have to justify. Equity cannot serve as a justification. We have to provide reasons why we end up to a conclusion, whatever the subject matter. It can be jurisdictional matters, as we discussed this morning. It can be substantive matters, as we discussed earlier this afternoon. It's also relevant for our discussion today. So I do believe that at the end of the day, providing reasons is what matters most. And equity cannot be an escape path.
And there's a real risk. Yeah.
There is also, this is thank you for explaining this new treaties provisions, and I suspect something similar is probably in the investment protocol of African Free Trade Continental Agreement. I think I have seen it. I think this is in a way a new generation of bits. It's exciting, but looking at the text, I was just scared. I said, my goodness, there's going to be another 50 cases to figure out what this means. I'm going to balance it. And so it's steps have been taken. There are some factors, but these are very broad factors. Balancing it. Let's balance it. And then kind of where is the balance? That's a kind of, it'll become very difficult, my guess is that, to kind of apply it in practice, but definitely improvement into what is what. So that's comment number one. Comment number two, I was lecturing to a group of African lawyers this last December, and I was showing them a similar provision in another treaty. And then after I started talking the possible implications, and I normally represent sovereigns, so I'm kind of explaining the negative implications for the investor, and these are all acting for private investors. All of them, they looked very sad and quiet. I said, okay, so what is left there? And I said, well, just, you can think of something, you're smart, etc. But we are kind of stepping into an era where I think these things are going to get center stage in a lot of what would be new disputes.
Thank you very much. Amelia?
My only comment really was I share some of the apprehensions that you do about hard skills, which is how I've been told you're meant to say it, but we all have a different idea. But I guess for me, it transcends the fact that it was originally a diplomatic espousal. It's been, I think it's been cited so many times by investment tribunals. It's incorporated in the ILC articles. It's recognized as a principle of international law that goes beyond the case where it began. So I'm not sure that we're applying it only by analogy, or that we need to analogize now, although I share your concerns, some of your concerns about the original constraints of the case.
But now I would like to give you the floor for you to tell us everything you don't believe in Chorso.
All right. Well, thank you very much for the invitation to speak today. And if I seem a little sleep deprived, that's because I have a 6-week-old baby sitting outside with my mum. So I'm very grateful that she's here today, so I can be here too. I think, I thought, I had this written. I said there's little doubt that the full reparation standard forms the bedrock of international law and that we wouldn't need to question that or discuss it. But there we go. Apparently that is in dispute. But I appreciate the overview that Borzu has given us. I think for me, the question that I wanted to raise is it seems to me that some of the more fundamental questions that arise in determining compensation or quantum decisions in the investment context just aren't really addressed by the Hartsoff case. As Borzu said, the case itself didn't even result in a damages decision, although I thought it was a really helpful elucidation to go through the questions that were actually asked to the experts, although we never got the experts' report and we don't know what the PCIJ ultimately would have done. It does give us, as you say, some hint of what the PCIJ was thinking in terms of how the but-for the but-for question might be addressed. But I think the result and where we are is that we have these broad principles, but investment tribunals are left with considerable discretion in how they actually determine compensation. And in my view, that's led to incoherence, contradictions, inefficiencies within investment decisions, where you're having every single time there's an argument about what quantum should be awarded, the same arguments are being wheeled out because there's not a lot of agreement about exactly how the principles apply. And I wanted to focus in particular on a question about how the but-for question should be applied, looking at the particular context of some of the renewables cases. So I think most of us will be familiar. There are, I don't know how many, I think in the tens, if not hundreds of these cases by now. I wanted to focus on a couple against Spain. So the broad fact pattern, as you will probably know, is that Spain granted a right for renewable electricity generators to fixed feed-in tariffs, among other things, to incentivize investments, and then subsequently replaced that with a much more modest regime, resulting in numerous investment claims, most of them under the Energy Charter Treaty, and in most of them, the tribunals have found that there was a breach of the fair and equitable treatment standard, although not of the expropriation standard. And I'm making generalizations, but I think that's broadly true. Tribunals have taken different approaches in these cases to calculating damages, although they are always citing to the Hartsoff case as the lodestar. The difficulty is in determining that hypothetical. What is the but-for scenario if the wrongful conduct by Spain in amending the feed-in tariff regime had not occurred? And so I'm going to just mention three cases, but as I say, there are streams of cases applying each of them, so they sort of represent different approaches. The first is the Nova Energia in Spain case in 2018. It's in the solar context, where the tribunal applies an ex post DCF valuation. And I think this is probably the truest, comes the closest to what was maybe contemplated by the PCIJ in Hartsoff. So it grants the investor the difference between the estimated value of its investment to its shareholders as at the time that the case was filed versus the value of the investment in the but-for scenario. And the but-for scenario is if the feed-in tariff measures had not been revoked. So it's sort of the purest version of how Hartsoff might be applied. And it also grants the investor historical damages. So that's sort of a straightforward down the road but-for scenario with a DCF model. Second approach is taken the same year in a case called RREEF, which I'm going to say REEF, in Spain. And the tribunal found that the claimants were not immune from reasonable changes in the regime applicable to its investment. And so, and I'm quoting, it is only to the extent that the modifications would have exceeded the limits of what is reasonable that compensation would be due and should be calculated. So in effect, it departs from, it expressly says that it's taking a different approach to what the ISA and the Novergia tribunals had done. It rejects the straightforward DCF method because it says, well, then you don't know whether or not the remuneration is actually reasonable. And that's part of the question that you have to ask. And so it goes on to grant a reasonable rate of return, looking at each individual plant that was at issue for the claimants, and ultimately applies a DCF model, but with the input of this sort of reasonable rate of return, which the tribunal itself had calculated. And then there's a third approach, which I would call the middle ground between these more two extremes, which appears more recently in the Radi, Sal and Spain case in 2022. The tribunal finds that the but-for scenario, you can't simply assume that the feed-in tariffs would have remained. You also can't assume that you can't make up sort of some hypothetical reasonable rate of return, which is what the Reef case had done. So instead, they say that there's this middle ground where Spain, there must be some acceptable margin within which Spain was entitled to regulate. So it applies a DCF methodology based on its own constructed but-for, where it says, well, this law would have applied, but only from this date and in this way, and it makes all these tweaks to the actual scenario and the but-for. So with those comments, I guess I came to this with a thesis that Harsof was no longer really fit for purpose, and that we needed a much more detailed articulation of how damages principles should be applied in the investment context. But actually, I think thinking about it more, I wonder if these inconsistencies are not arising from problems with quantum. Actually, the Hartsof principles have had incredible longevity, and they articulate the but-for test. And it's really just a question of how that should be applied in a particular factual context. Now, I think the thing that's striking about the renewables cases is you have these three different cases applying effectively the same basic facts, coming to quite different results on quantum. But is that because the test is not clear, or is that actually a liability problem or a problem of how it's being applied? And in particular, I note that Philippe Sands dissented on liability and quantum in the Radi case. And part of his dissent is criticizing the melding of matters of liability and quantum. So he's effectively saying the tribunal is saying that on quantum, there should be some level of reasonable regulation where Spain has some right to regulate within certain bounds. And that comes in at the quantum phase. But should that instead be considered in determining the scope of liability under the fair and equitable treatment standard to start with? So I sort of came full circle. Maybe Hartsof is actually good and we shouldn't be trying to meddle with it because it's lasted for so long, and maybe instead we should be focusing on questions of reasonable or exactly how the liability is being applied. And my final comment is just to say if we are looking to amend the investment treaty, how quantum applies in the investment treaty context, then of course there are proposals to consider a proportionality requirement, but for me that comes into the same sort of problems of the amount of discretion that gives tribunals. So I'm not sure that that's really a panacea. Or there's been the proposal by Martins Paperinskis to have some sort of compensation exception where the compensation is crippling for a state. So I simply put those on the table without passing much more comment on them. Thank you very much for the opportunity to speak to you all, and I look forward to the further discussion.
Jason, you wanted to say a couple of things on DCF. Can you start with that? Yes, no, since she was just talking about DCF.
Can I comment on that?
Yeah.
Or we don't have time?
Let me just first take Jason comment on DCF, then
Do it as a whole.
we should be fine. We are still good with time.
Yeah. Shall I sit or?
No, just start first on DCF,
Yes.
and then later you take your main presentation.
I see. Yes. Yeah. No, I think. I mean, I agree with where Amelia got to.
How boring.
I do
That's
think
what I
it's more.
disagree. So at some point,
I do think it's more a problem of application than principle, really.
Yeah.
I think there's an issue really with the way tribunals perhaps apply valuation method, and perhaps DCF in particular. There's an over-reliance on sort of this factual inquiry than perhaps questioning the legal assumptions and following what the investor is really legally entitled to. So yeah, I think that's my take on that. I agree with you, and I don't think Chorzo is bad law. I think it's good law. It's the application has been problematic in certain cases.
Yeah, then Borzu.
I think I agree. I want to take us back to Chorzo because about the point that the second Spanish tribunal has made, that the idea that when you're building the but-for scenario, you just cannot assume the life would have stood still, frozen in time. Things would have evolved. So then to resolve the part that relates to for example, the previous owner, let's say the property has been taken, handed down to some Polish entity running it. The court said that, well, you just have to assume that it would have remained in the hands of the German owners. Elsewhere in the judgment, it says, well, if you want to kind of figure out, I guess, how they would have run it compared to the new kind of operators, you could have looked at, for example, other properties that they're operating to get a sense of how they would have kind of planned, although there may be some plans already on the table in that. But going back to this idea of the acceptable margin of, what would have happened, that's kind of a very interesting. I have dealt with it in the context of other cases, oil and gas case running for a long time. The breach happened 10 years ago. We were still litigating what would happen. And then during these 10 years, the government has enacted a bunch of other regulations, legislations, etc. And claiming party saying that no, none of these applies, respondent said, no, I mean, if the life cannot stand still, if you would have continued operating, you would have been subjected to this. And then the question becomes that, okay, I mean, under Chorzo, you exclude the illegal acts. If they're not illegal, then you almost are presented to litigate. Okay, let's litigate the new legislation. What would have happened if they had stated this new law was enacted? The next one. There's almost an endless series of measures coming. We'll have to litigate it to decide whether to exclude it or include it. And so I just leave it at that as a practical problem. I guess that was a very unusually large case. And
on all these DCF issues, I wanted to ask you, Yannick, is it helpful to have a quantum expert? Does it make a difference?
Actually, I wanted somehow to address this point, contributing to the discussion. So, because here, I mean, inconsistency in how Chorzo is applied. Well, again, we could have spent the day speaking about the coherent application of the law in investor-state arbitration. But I think here, in addition to the vagueness of the law, so we have the principle, but then how to make it work in practice, there is some vagueness. So in addition to the vagueness of the law, I think there is also the responsibility of the actors in investor-state arbitration proceedings. And here I'm thinking I'm thinking about arbitrators and the extent to which they master those economic/financial aspects. There is the responsibility also of the parties and their experts who do not always help the arbitrators to make sense of quantum matters. So to get back to your question, they have the potential to help, but sometimes I remember like Duggal saying, okay, so we have the expert for the claimant here, we have the expert for the respondent there, and so what it's, at the end it's useless. Then the arbitrators have to make up their mind themselves. So I think that the actors play an important role also to rationalize how quantum is calculated in investor-state arbitration. But hopefully, in the coming years, there will be some guidance. And so Working Group 3 know that this is discussed as part of the cross-cutting issues, but in the current draft, there is, in the end, very little. But maybe that at the IUSCT, we can expect that in the coming years, they will come up with more detailed guidelines to apply short session.
Thank you very much. Now I go to my last but not least presenters. Jason, you already published an entire monograph of compensation for environmental harm. So it prompts me to ask you, okay, is George so relevant there? So I give you the floor for your presentation.
It is, but I might just pick up on DCF and speak a little bit more about those problems or the problem of using DCF in cases that have sort of an environmental dimension. As of course is well known, investor state arbitral awards, especially in the extractive sector or industries that have a significant environmental impact, there's been really large awards of compensation stretching into the millions and billions, of course. And I think one key factor is the use of the discounted cash flow method. Rather than focusing, of course, on sunk costs or actual expenditure, DCF treats compensation as covering not just losses incurred, but also expected future income streams. And with DCF, as I touched on in my sort of comment on Amelia's paper, the focus is often more on the factual or financial questions, like the likelihood of profitability or the reliability of projections. And sometimes there's not a sort of a detailed examination or critical reflection on the underlying legal rights. And some have raised concerns that some of these current approaches may lead to awards that go beyond what is required to achieve full reparation. Of course, I have in mind cases like Rockhopper versus Italy and similar cases involving extractives. And there's also sort of broader policy concerns. So particularly in cases involving sectors such as fossil fuel sector and where social and environmental and regulatory context is rapidly evolving. And the DCF method often assumes a relatively stable entitlement to future earnings, but in contexts where climate regulation or energy transition or public policy shifts may evolve quickly, this of course will affect the future operations of companies. And I think that needs to be more closely scrutinized by tribunals. I think there's a few ways in which some of the issues that pertain to the application of the DCF method might be assuaged. So even if the DCF method is used, there are of course ways of integrating through the discount factor itself certain regulatory risks, environmental risks, market risks, etc. And then of course we can question whether DCF is right at all. I think it was in the dissent of Judge Brower in the Iran-US Claims Tribunal case Amoco in 1987 that this kind of first really raised its head. And tribunals have sort of sometimes unquestioningly relied on DCF. But there may be, as in Rockhopper, I would argue, alternative approaches that would be better suited, particularly where there are environmental or social issues at stake. And then third, I think equity should play a greater role in the determination of reparation. Obviously shouldn't override legal principles, but I think equitable considerations can play an important role in contextualizing the application of legal principles, taking into account conduct, of course, or proportionality, or other sort of broader circumstances, environmental change, regulatory change, etc. And of course, this panel is about what we can learn from the ICJ's case law. There's been a number of recent cases where the ICJ has endorsed and relied on equitable considerations that I think provide an interesting recognition of equity, and maybe some of the reticence in ISDS around the application of considerations is somewhat unfounded at times. And of course, I think Yannick mentioned, others have mentioned that Ancestral Working Group 3 is looking at some of these issues. The draft provisions on procedural and cross-cutting issues did have a number of interesting things in this draft article 23 that's now 20, but unfortunately, that some of those sort of safeguards that were supposed to restrict or provide some accountability around excessive awards, have been watered down in this most recent draft. And as Yannick said, let's see what the ILC says. It will be interesting to see whether the ILC can provide some clarity on compensation more generally, and perhaps ISDS can learn from this too. So yeah, I think the problem isn't always just the size of the awards. Sometimes it's the legal assumptions behind them. There is this sort of uncritical application, I think, of the full reparation principle and DCF in particular. And so the principle of full reparation shouldn't just be a blank check, but it must always be applied in light of contemporary risks, environmental risks, regulatory risks, social needs, and other legal developments. So I'll leave it at that.
Thank you very much. Any comments from my panelists? Borzu?
Well, I think that there is a lot to comment, but I think one of the aspects that's interesting, I think, is just how to deal with the risks. And Jason said, let's deal with the discount rate. And discount rate is one of those very problematic things if you're particularly on the receiving side of a very large award. And I have been in cases where we just had the discount rate expert on top of the normal damages expert and others. Because one guy, just his task was to calculate the discount rate. And it's at some point, there's just so much you play with these formulas. There's look at Damodaran's listings, etc. And it becomes very subjective, and little changes could dramatically change the amounts. I think so. A little bit more energy is spent on that, and funds to create maybe some sort of a guidelines would be useful, particularly for this field when the amounts could be very high.
Yeah. Anyone to pick it up?
Okay.
Yes, please. Yeah.
I just wanted to make one comment because there's been a suggestion of, well, if we need clarity, where is it going to come from? Is it from the Working Group 3? Is it from the ILC? The other possibility, which I'm just going to put on the table, is the certain Iranian assets case, which is pending before the ICJ. And that may be an opportunity that, as far as I've seen, the parties have been sent away to try and settle the damages question. I haven't seen any press release from the court that they have come back. Maybe others know better than I do, but I haven't seen that. But that time has now expired. So it may be that the damages phase now starts. And that may be an opportunity, really for the first time in nearly 100 years, for the ICJ to make some comment on the way that compensation should be awarded in a complex situation that may have some analogies to the investment context. Because I think the problem is, when you look at the ICJ decisions that have happened since the PCIJ case in Hartsof, most of them are very hard to analogize to the investment context. There's no application of DCF. If you look at the Costa Rican Nicaragua case, it's about how do you value a tree. It's quite hard. Usually it's hard to draw any analogy to that. So then maybe we'll have some sort of authoritative statement that could influence the way that investment decisions go forward. So just put that on the table as well. There may be hope.
We should conclude on that.
We should conclude on that, and but I need to give the floor to the room. I hope you have.
No,
No? Okay. Yeah. So I need. I will now open the floor for the room and the audience. Anyone with a
I
question?
have a question,
Yes.
Mamadou.
Yeah.
Perhaps to Borzu, but and to anyone else. In the Corfu Channel case, when it came to valuation of damage had been advocated, experts been appointed by the parties, and then the court appointed its own. And came down to an evaluation which was superior to the one claimed by applicants. But the court decided to refrain from awarding damages that they had evaluated because they thought this would be ultra petita. If you put this decision against the background of following case law, both in the ICJ and in investor state arbitration, what do you reckon would be the answer based on your experience? And I think, Borzu, you were hinting at some experience in that.
Well, the idea of tribunals hiring their own damages expert, I have seen it a couple of times. And what happens is, my experience wasn't like Corfu Channel cases, they kind of came somewhere in the middle. And then you kind of get unhappy because it's, for example, closer to claimant's number or closer to respondent numbers. It happens that a lot of times they're far apart. But whether that's a good idea, I mean, tribunals, I think it's an honest thing to do if you're not comfortable with the numbers and you don't trust the parties and their experts, you kind of better hire someone and then see what they say. It makes the process, as you know, is a little bit more complicated, more expensive. You have another person there, then you have to be pleaded, then you have to comment on the new expert. They're probably a substitute to the extent possible. Maybe I've seen in at least 2-3 cases where the tribunal forced the parties and ordered them just prepare one consolidated set of reports and agree on these things. And then that's a bit more useful, but the product ultimately, again, there may be 2 scenarios, and just to give the numbers. But yeah, I think that's...
No guidance from the ICJ this time.
Yeah.
So Cameron had a point.
Jason.
Yeah, maybe just to add, I think, the ICJ's practice on the appointment of its own experts has, of course, been quite inconsistent. Yes, in Corfu Channel, not in Diallo, not in Costa Rica, Nicaragua. I think in Costa Rica, Nicaragua, there was really an argument that they should have done because the parties were so far apart in their estimates. But they did so, of course, most recently in DRC, Uganda. And I think actually perhaps maybe the ICJ could learn from some investor state dispute settlement. Perenco versus Ecuador, I think, is a really good example of where the parties were really far apart. And the tribunal felt the need to appoint its own expert, Scott McDonald. I think it put in place a really interesting procedural safeguards. And I think that's quite a good model of how the tribunal could employ its own expert and put in place the right safeguards. Similarly, Burlington resources versus Ecuador. I think that's quite an interesting model as well. So yeah, if the ICJ could be a little bit more consistent in the way it has recourse to independent experts, I think that would be a good thing. And it seems to be going in that direction. Actually. Thank you very much.
Yes.
Yes, first of all, congratulations to the panelists, excellent presentation. So I want that sort of factory is not always about full compensation. Sort of factory is not about reparation. Compensation is only one of the 3 forms that reparation may take. So arguably, in the scenario that restitution, compensation, and satisfaction, all taken together, could lead to meeting the standard of reparation that sort of factory is. And perhaps this would be the way to understand the ICJ jurisprudence using equitable principles when it awards compensation, not when it discusses, it starts from discussing social, but then it discusses compensation. Now, the point that Tila made is also another indication that even perhaps what the court is not always about full reparation, because according to the court examiner, the experts of the court found that full reparation would require more compensation than that requested by the parties. But there, it was a judicial function that said, no, I won't be providing full reparation. I will be providing what I have done. So I would like to hear your reaction.
Yes, Yannick?
Yeah, I mean, as a matter of principle, there can be various combinations to achieve full reparations. So it can be restitution, or if materially impossible, that can be compensation only, or this can be a mix of restitution and compensation. So various scenarios open depending on the facts of the case. So yes, sorry about
I think the question of why restitution is not regularly awarded in investment decisions is a very interesting one. In most cases, there's not even discussion of that question, although everyone is citing to Hartsoff, and the presumption in Hartsoff is that you would give the property back. So the presumption is one of restitution, not one of compensation, and that presumption is also embedded in the ILC articles. But in most cases in an investment decision, you don't even see the tribunal grappling with it. It's taken as a matter of course that you go directly to compensation. Why is that? Different reasons have been given. I had originally prepared some comments on this, so I happen to have some cases in front of me. So, for example, in the Pizzold and Zimbabwe case, the tribunal quotes pragmatic concerns. There's a concern about overstepping the boundary, and so in the LG&E Argentina case, compelling Argentina to do something that might unduly interfere with its sovereignty. So those are the sorts of concerns that tribunals might have in mind in the few cases that they do address it. On the other hand, a very big compensation award is also an imposition on a state's sovereignty. And what I think is interesting is traditionally the ICJ has been quite reticent about making big compensation awards, or often any compensation awards. It says the mere fact that we state that there is a wrong is sufficient satisfaction, because, and that for it is enough. Or in some cases it does order restitution, but compensation is less common. What I think is interesting is that in recent years we're starting to see that change. ICJ claimants are coming and asking for compensation. The court is more and more looking to make compensation awards. So maybe we are actually getting a sort of the two fields are moving closer together.
But related to that, if I may add something, this is very interesting, and part of it, when you opt to sue a government, essentially it's like an exit strategy. Yeah. You can sue, bring a multi-billion-dollar claim, and then kind of it's over. I'm going to get the property angle. It just makes things very sour as a kind of a business perspective strategy. And most of the cases, this issue is driven by the claim. You just kind of, I have been on the receiving side of this claim. I almost can say, in 20 years, I haven't seen one request for returning the property in tens of cases. Not even one. I have read it in other awards. I have read it in other awards. The other aspect, which is more legal, I think, goes to the enforceability, the limitations in IUSCT Convention on enforcing only pecuniary obligations in an award. So once you kind of, and then a claimant says, okay, I mean, I go 10 years of litigation, etc., first case annulment, etc., I cannot enforce a request for restitution. What's the point of it? You know, let's ask for the money. And that kind of appeared in a bunch of treaties too.
Yes.
Follow on Borzu's point, it's very interesting to analyze the same question from the perspective of not necessarily, I guess the research would be very difficult, but it would be interesting to analyze the same question from the perspective of investor state arbitration disputes that have led to settlements. Because in those cases, of course, there is the hope by the investor that some sort of reparation will be provided. If not, the factory or the airport that was given to another investor, perhaps another concession in its various forms could be thought of or even researched from that perspective. But I acknowledge that it would be very difficult because those settlements are
Not available. Yeah.
Yeah. Good. Any reaction?
I think it was the answer.
Yeah.
The idea is great, but
Yeah.
good luck getting your hands on the settlement
Settlement agreements, yeah.
documents.
Is there
Yes,
some time
please.
if there is no no, there is a question.
Yes.
Well, I just might have a comment based on the last point, because there was a recent case where the opposite happened,
Mhm.
where it was a going concern. It's the United Group versus Serbia case. It was a going concern. They had a number of claims for fair and equitable treatment for the continuing company.
Mhm.
And the case ultimately settled by having a sale company purchase the investment, because it obviously they couldn't continue to operate in the country after
Mhm.
bringing such a large claim against the country.
Yeah. Anyone else? Yes.
Yeah, just something that you said, both about legal illegal act and aspect of shows which
Yeah.
have been under the radar.
Yeah.
So actually, it makes me think of the fact actually the influence and the relevance of ICJ and PCJ judgment. I mean, they cannot be discussed in abstract. Or we have to take into account the context, but most importantly, we have to take into account who is sitting on the bench.
Mhm.
And if you look at the case law about the MFN, so I'm sorry, I will not talk about Casinos Austria for once. Yeah, because we've been discussing this case for whatever reasons throughout the day. So, but if you look at Daimler, who was the president? Pierre-Marie Dupuis. How many references to ICJ cases? Many. In Pregilo, who dissented? Brigitte Sepp. How many references to ICJ? Public international mindset, it's obvious. So I think that when we think of the influence, and when parties think in terms of influence, that's largely a matter of who you appoint as an arbitrator. And we can witness that some parties want ICJ judgment to have an influence, and other parties do not want the ICJ to have such an influence. So it has really a contextual and relational dimension, this whole debate.
Any other question? I had a few questions that I had for my panelists, but feel free to come as you wish. It really comes from the perspective of procedure, pure procedure. There is one procedure that you see a lot at the court, which is that after the finding on liability, the court will tell the parties to negotiate the compensation. And it's only when the parties have failed to negotiate and agree on the compensation that the court will then take up the case. So that's what explained that, for instance, Congo versus Uganda, you have a judgment in the early 2000s, and then the compensation judgment almost 20 years later. And think about the parties who are trying to gather evidence. It wasn't easy because of a war in the Congo during the early 2000s, how much more difficult it has become 20 years later. So I wanted to ask you, what do you think about this distinction between the liability decision and the compensation decision, and just giving the parties the opportunity based on the finding of the tribunal or the court to just to try to agree on the amount of compensation? Don't ask me why, because I guess it's because everyone knows that compensation is difficult. So, yeah. I have 4 people.
Everybody
Ladies first. Yeah.
I will be very brief. I think that a big part of the reason why quantum experts appointed by each party come to the tribunal with reports that are so far apart are because their counsel instruct them a series of assumptions that they are to assume which meet their case. And so one party says, here's what the claimant says based on these assumptions.
Mhm.
The respondent says, no, I want you to make these other assumptions, and it comes out with a very different result. The advantage of the approach that the ICJ takes is then you have hopefully also a series of directions from the court on how compensation might occur. Now, you didn't have that in the Congo-Uganda case. You do see that in investment arbitration, where there's a decision on the principles of quantum, and then the parties sometimes are invited to go away and try and settle based on those principles. And if not, the quantum experts are invited to come back to the tribunal with a joint report, taking those assumptions into account. Now, you're not always going to get agreement from the two quantum experts, but the advantage of that is they then come back with something closer together, and they've maybe narrowed the field of the decisions that have to be made.
Yeah.
I think it's useful. It just delays the process sometimes considerably, and it adds cost, because in my experience, that's another 6 months, maybe 12 months to the time the lawyers remain involved, so everyone's costs go up. That's the disadvantage.
Listen. Yes,
So, I mean, as counsel, you would want to, and usually it's just like forcing your hand to kind of, because you strategize this, you want to lead it, etc. And of course, I think the tribunal has the power to force to kind of a talk, but oftentimes, as I said earlier, the case begins because just there was almost no talk. Maybe there is an avenue here. Once there's, for example, a liability, you see, you really need to go and talk. But in my experience, settlements do happen, but then the question is when. And usually very late after the parties have pleaded their damages, there has been a memorial, there's been a counter, and maybe in a rejoinder, and then that you can see the strength of your case. You know what, let's just go talk to them. And that has happened 2-3 times in cases that they but it happened after kind of litigating the full case. The positions have been narrowed, the points of the strength and disadvantage are kind of popping out. You can see them right at the level of kind of a court thing, that those stuff are not, and that puts the parties in a kind of a, might not be, they might not be doing that. And I feel that the investment tribunals, being as ad hoc appointed tribunals, they're kind of very cautious just to allow the process to be driven by the parties rather than they drive it. But I don't see why that cannot be happening. That's if the tribunal said, okay, both of you are at the center, go and see if you can talk.
Yannick?
Yeah, I fully agree. At the end of the day, I think more than any other process is driven by the parties. So this makes a difference. Another element is also the prospect of the negotiation. Is there any chance that it may lead somewhere? So it depends on the relation between the parties and the firms. If there is a will to collaborate, then it may worth it. Otherwise, maybe not. But in procedural terms, something interesting is when tribunals decide on principles, actually, first, and then it applies to go further. So
Jason?
Yeah, I think it's in general a good idea to have separate proceedings. I think it was first maybe in the fisheries jurisdictions case that the ICJ expressed a preference for a separate proceeding on damages. But I think as has been said, it provides for an opportunity to work these things out between the parties. There is, of course, sort of a point of judicial efficiency there. The ICJ has only decided 4 compensation cases. Perhaps that's one of the reasons. And yeah, I think there is merit in having separate proceedings where the parties can fully plead their claim on damages.
Okay, any last thought? Because I see that we have to hand over the floor at 45, but I share their last thought. Yeah. Yeah, Jason.
Yeah, no, I mean, just coming back to what you said earlier about DRC, Uganda, it's interesting, you know, unfortunately, you know, the court did take this sort of global sum approach, but I think the court was obviously struggling with evidence, right? And it was working on this idea of applying evidentiary discount factors for things that, were evidence that had maybe been lost. So I think these kinds of things where you lose evidence or evidence is uncertain, and we could find some more systematic way of accounting for that, rather than just going to this sort of global sum approach, would be good.
Yeah, but the global sum approach really was adopted by the court because, as you mentioned, the evidence was not specific enough. There was also some very troubling questions to really adjudicate. How much do you value the life of a person? And then the maiming of another one. These were very difficult questions to answer. I think at the time I was at the court and I could really see the difficulty. And for the parties, of course, 20 years later, if we have to try to identify all those who have been injured in the Congo war, it was becoming almost impossible, and therefore the court kept giving them opportunities to substantiate their case, but they weren't able to actually bring anything else. May I conclude? Yeah. Okay. So I think that the audience, both in the room and online, is now wondering, where do we stand with Chorso? It's not because my panelists didn't do a great job. They did a fantastic job. The reason why we are still wondering where do we stand in Chorso is that, first, do we really need to have Chorso as a key reference point in legal argumentation? The reality is that we take Chorso as a key reference point in legal argumentation because of the nature of our system. There are certain domestic judicial systems where issues of reparation and quantum are a big volume, a big code in itself, but we didn't have anything. And what we had was Chorso. So we did with what actually we could. Now, I don't believe that Chorso created the notion of full reparation, including the definition there. Because as you were talking about it, I was thinking about my course in 2L. Yeah, so second year law school, we define exactly the principle of reparation this way. You have to do as if the breach didn't occur. So basically, it's a concept, at least in the it's just a general concept of law that has just been put there, and that may explain why it became very successful, but also did not guide enough because no one dared going through the general principle of law part in order to see how different domestic judicial system substantiated the principle of full reparation. I also think that there is also really a step back that we need to take when we discuss this issue of compensation. I still struggle to see a breach of FET and expropriation being governed by the same principle. I just feel that different breaches of different norms might be governed by different principle of compensation. But of course, if you just have a hammer, then everything would be looking like a nail to you. And therefore, Chorso got to expand probably beyond what was in the what it was thought about. There is one thing that I don't see sometimes in discussions with respect to Chorso. Chorso dealt with expropriation, and I believe that there is at least just as a matter of legal theory, I understand we have, okay. The organizer will be done in 2 minutes. I think Chorso dealt with expropriation as a matter of legal theory and also practice. There is a difference between expropriation that is null and void, and therefore suppose as a matter of law never to have existed, right? Null and void, and expropriation that is unlawful, which is expropriation which existed but did not satisfy some of the requirement for expropriation. It makes sense for me, and this view has several legal consequences. It makes sense to me that if you expropriate when you no longer have the right to expropriate, the value of the expropriated asset has to be determined on the day when the tribunal is rendering its judgment. Why its award? Because you are presumed to have kept the ownership, the title to the asset through the day of the award. But if you had a right to expropriate based on your permanent sovereignty over natural resources, because the treaty allowed you to do so in the specific context, then I would say that the date of valuation is the date when you expropriated, irrespective of all the fluctuation in value that could have occurred with respect to the asset. So I see now this trend about dealing with providing more guidelines to tribunals. I'm not sure so far whether it is the right way to go. For one reason, usually when you deal with norms with variable content, such as full and equitable treatment or full reparation, or take all the norms that will have a variable content. The best way to substantiate them is through practice. Because practice is what allows you to see in this circumstance, this is where we go. In this circumstance, this is where we go. It's not general, I would say, theoretical theories again about these scenarios that work. So, but this, I think I abused my role as a chair. I would like to thank you all for your attention and to, of course, ask you to thank the panelists.